Mr. Spence.
Good afternoon, Madam Chief Justice, Justices. My name is David Spence, and my colleague's name is Mr. Porter, and we represent Mr. Morelli, the respondent in this matter. Police searched Mr. Morelli's home and seized his personal computer after obtaining a search warrant. Child pornography was found, but while the law must be relentlessly enforced, the moral outrage caused by child pornography must not be allowed to blur legal requirements or undermine constitutional safeguards. The question in this case is whether the warrant authorizing the search of Mr. Morelli's computer was constitutionally valid. In this case, it was not. Mr. Morelli's Section 8 rights were violated, and the evidence should be excluded. I will argue that the ITO did not disclose reasonable and probable grounds, and my colleague, Mr. Porter, will speak to the exclusion of evidence. There are only two inferential paths the justice could have taken in issuing the warrant here. The first path is the opinions provided by the officers describing Mr. Morelli as the type of offender that would save and collect child pornography. The second inferential path the justice could have taken in issuing the warrant is the presence of the icons observed by Mr. Hunjet.
But do you accept that, dealing with your first path, that it was legitimate for the warrant to issue if it was expected to find pornography that only comes in the future? No, in other words, it only comes after Mr. Hunjet was in the house and saw what he saw? In other words, a propensity to have it, to continue to access it and therefore to find something that he accessed later.
There's nothing to suggest that Mr. Morelli has that propensity, Justice Feldman. Both of the officers talk about types of offenders or simply offenders, but they don't tell us what this means. They don't provide sufficient details about this class of persons. And apart from that, this is expert evidence that is being given by individuals who are not experts.
Are you referring to the fact that the so-called child pornography part was found amidst largely legal pornography? Is that what you're alluding to? That there was no reason, and of course this is something they found after the fact, they didn't know before the warrant. So how does it affect the decision of the issuing judge?
The child pornography that was found after the fact certainly cannot be used to justify the legality of the search. But both of these officers are describing Mr. Morelli as the type of offender that is going to save and collect and hoard and archive child pornography. But Mr. Morelli cannot be presumptively classified as such an offender. And that's because the ITO doesn't address the fact that not all offenders or not all people who are interested in child pornography will have identical offending characteristics. Someone who seeks out images of young children or infants will probably have different offending characteristics than someone who seeks out images of teenage girls under the age of 18. There's no way to conclude here that all child pornography offenders are going to save and collect and store the material.
Well, do we have, what is the standard? Isn't it enough to show that most of them do? And doesn't that suffice to base a reasonable inference that this particular person did, that is, store the images?
In this case, Chief Justice McLaughlin, what we need is a reasonable probability, not that most people or not that most individuals who are interested in child pornography will store and hoard the material, but that Mr. Morelli is the type of individual that is going to treat the material in that manner. This ITO does not show us or does not link Mr. Morelli to the class of persons defined by the officers.
What would be needed to do that?
Something more is required, Justice Feldman, and I can't describe with any degree of exactitude what is reasonable grounds, but what I can tell you is that this is not it.
Well, what's missing?
This ITO is missing reasonable grounds to show that evidence is going to be in the place that is to be searched in January. It serves to remember that in this case, the icons observed by Mr. Hunjet on the date of his first visit were no longer present on the date of his second visit. Even if the appellant's definition of possession is accepted, it's likely to have disappeared by the time that the search warrant was executed. It's likely to have disappeared with the removal of the icons and the formatting of the hard drive.
Well, it's argued that the fact that they were removed the second day is some sort of consciousness of guilt, showing that he had intentionally set up these favorite links and was very interested and was just the kind of person that you say there's no evidence to show he might have been. In other words, the removal doesn't help him, but rather makes him appear more like a classic offender of this sort.
Not necessarily, Chief Justice McLaughlin. It's equally plausible in our submission that Mr. Morelli would have realized that what he was doing was illegal and may very well have never accessed child pornography ever again. That scenario is equally plausible. And 2 suspicious icons and a suspicious desktop is not enough to properly characterize Mr. Morelli as the type of person that is going to put evidence back on his computer or that is going to store and hoard child pornography. To rely on these broad generalizations really relies on stereotypes.
What do you say about the expert evidence at the voir dire that Mr. Morelli had the characteristics of a child pornography offender and that such offenders have the propensity to copy numbers of illegal images and store them in their personal computers? What do you say about that evidence?
That evidence is not particularly helpful in this case, Madam Chief Justice. And
Not to you, anyway.
that is evidence that we that's evidence that we learned about at the voir dire. The case of Arujo makes quite clear that we can only amplify the ITO with information that can be construed as a technical, minor, or good faith error. This expertise, or this expert opinion, is something...
Are you saying it should not have been admitted into evidence at the voir dire? Is that your contention?
Yes,
that
Madam.
it went beyond amplification and it should not have been admitted?
Yes, Justice Hessler. It should have been put in the ITO at the time the information was sworn and placed before the Justice of the Peace. This is not a minor technical error, and it comes very close to circumventing the prior authorization process, and that's not what we can allow in this case.
And in response to the issue of the icons having already been removed, your opponents seem to claim that despite the formatting of the hard drive, a forensic examination of the content remained possible. How do you respond to that argument on their part?
There's nothing in this case to suggest that that type of forensic analysis is
Was
possible,
possible.
Justice Hessler.
Okay.
The ITO in paragraph 12 quotes Corporal Boyce as stating that information will remain inside the hard drive of the computer. But that suggests only that files originally stored on the hard drive might be recoverable, not that anything ever viewed on the internet would similarly be retrievable. It serves to remember that the icons in this case were links to not links to internal locations on the computer's hard drive. They were links to external public websites. So the fact that Corporal Boyce says information will stay on the hard drive is not very helpful in this case. The Supreme Court of Canada correctly defined the level of control that is needed in order to make out possession, and this argument can be found at paragraph 35 of the Respondent's factum. My friends and I don't dispute that control is the defining element of possession, but the Crown has incorrectly defined the level of control needed in order to make out possession. Control is only established where an accused moves or starts to move the underlying data files of the child pornography content from the public domain of the internet onto his computer. Merely accessing or viewing a website is not enough. Greater command and greater dominion over the content is required. In the case of Chalk, Justice Doherty noted that, in the Ontario Court of Appeal, Justice Doherty noted that control really refers to power and authority over the item, whether exercised or not. Power and authority is not established where an individual views or accesses a website that any number of other internet users can simultaneously access and view.
I'm not sure if that's right. Whether exercised or not, doesn't that go against what you just said? I mean, as long as you have the ability to do it, and we know how easy it is to do it, don't you have power or control?
What we need, Justice Feldman, is power and authority over the item that can be possessed. The child pornography is made up of two components. We have the video or the image, and then the underlying data file. The video or the image is only a projection of that data file. It's the file that is the stable object that has some measure of permanence. It's the data file that can be stored, distributed, destroyed, and indeed possessed. It's this approach that is most consistent with the case of Chalk, and it's more faithful to our traditional understanding of what it means to possess something. We also have the separate offense of accessing to capture the very circumstances that my friends have described. The ITO in this case did not allege the offense of access.
Might I ask you if, even though the penalties are the same under the applicable provisions for both possession and accessing, could it be possible to envisage accessing as an included offense?
No, Justice Hessler. Accessing is not a lesser included offense of possession, but the manner in which the Crown treats the two offenses completely subsumes accessing into possession. It renders it redundant. Indeed, it's very difficult to imagine a probable situation where an individual would be guilty of possession without also being guilty of accessing. And it's this treatment of the two offenses that really violates the principle of statutory interpretation against redundancy.
Well, your friend says that if you went to a child pornography theater, if there were such a thing, I don't suppose there is, but let's say you deliberately go to a place where these things are being shown, that you could be charged with accessing but not possession. What do you say to that?
In our submission, Chief Justice McLaughlin, it could not have been Parliament's intention to restrict the offense of accessing to such a narrow set of circumstances that are highly improbable. Accessing was created very thoughtfully. Parliament specifically turned its mind to the nature of viewing child pornographic websites. And the offense of accessing demonstrates that it's simply not necessary for this court to blur and bend and stretch our traditional notions of possession. That's not necessary.
In the United States, is downloading required for control? Can you assist us with that? Possession?
I'm not sure if downloading is required in the United States, Madam Chief Justice, but what I can tell you is that in this case, in Canada, if we draw the line at downloading, it injects a certain amount of clarity and certainty into the criminal law. It puts all Canadians on notice that when they start to download, that's whenever their actions are going to be considered criminal possession. I notice that my time is now up. Those are my submissions. Barring any further questions, my colleague will now speak to the exclusion of evidence.
Thank you, Mr. Spence. Mr. Porter.
Good afternoon, Chief Justice, Justices. My submissions relate primarily to Section 24.2 of the Charter. This argument starting at paragraph 60 of the Respondent's factum. Inclusion of the evidence obtained as a result of the breach of the Respondent's Section 8 Charter rights in this case would bring the administration of justice into disrepute. and ought to be excluded as a result. At the first grant factor, the charter infringing state conduct was serious. Justice Fish, writing for the majority of the Supreme Court of Canada, held that the ITO in this case was carelessly prepared, was materially misleading, and was factually incomplete. This in violation of the duty that all police affiants owe to make full and frank disclosure to the issuing justice.
Well, your friends, of course, say the opposite. They say that any errors or inconsistencies were inadvertent and everything was done in good faith, that any mistakes were very minor.
The respondent disagrees. The errors in this case had the effect of painting an unfairly villainous light of the accused. And the seriousness of the seriousness of the police conduct in this case really is grounded in the exceptional nature of the duty to make full and frank disclosure. This is a duty that applies to all moving parties in ex parte proceedings, whether it be in the context of the warrant process or in the civil context with Riva injunctions or Anton Pillar orders.
Well, what did they fail to disclose that they should have disclosed?
The duty of full and frank disclosure requires in part that the known facts be presented in a neutral and impartial manner. The affiant in this case failed to disclose, well, it was in fact a case of over-disclosure. It included erroneous references to child porn at paragraphs 5 and 10 of the information to obtain. These are references which are simply not grounded in the source material. They are erroneous and are misleading on a natural and plain reading of the ITO, particularly in the context of paragraph 5, which contains references to the child, the webcam pointing towards toys, and omits the material, well, it omits facts which would dispel with any suspicion which is raised in paragraph 5, which is the first substantive paragraph in the information to obtain. And the natural reading of the ITO is to give rise to an unfair picture of Mr. Morelli, which is simply not grounded on the true facts known to police.
But if we rely on the new facts which have been provided, the homepage was set to Lolita porn. Isn't that enough to sustain their contention?
No, Justice Hessler, and that's because on the correct interpretation of the law of possession that my colleague has put before you, there is no certainty in that actual child porn was viewed. The homepage setting is not necessarily child porn, and the conclusory references to child pornography throughout the information to obtain lead to the natural perception of the issuing justice that there was actual child pornography videos or other actual child pornography viewed on the respondent's computer when in fact there was not.
Well, why would he have his home page on Lolita porn if he wasn't interested in viewing it?
The respondent concedes that that particular fact is not the focus of the inquiry here. The focus is the police conduct in failing to disclose all facts known to them at the time that they were seeking the warrant. And the failures to make full and frank disclosure in this case are particularly serious, having regard to the centrality of the prior authorization process to the minimum constitutional standards guaranteed to every Canadian citizen under Section 8 of the Charter. As Justice Dixon, as he then was, noted in Hunter and Southam, the prior authorization process forms a critical part of the privacy protections of every single Canadian citizen. Furthermore, Justice Rosenberg, in the case of Regina against Hosey, noted that the issuing justice is only able to effectively weigh the competing state and individual privacy interests when they're provided with an accurate and candid presentation of the facts.
Well,
Mr. Morelli
the webcam was pointed toward the toys, wasn't it? What was misleading about the information about the webcam and the child?
The use of the word webcam implies, on a natural reading, use with the computer. However, it's only later in the ITO that we discover that the webcam was actually pointed towards, or sorry, was actually connected to a VCR recording to videotape. and this dispels the natural suspicion raised at paragraph 5 that there was production of child pornography. And in fact, it's much more plausible that the divorced man in this case was recording his child at play for posterity's sake, that there is no probability-based likelihood that Mr. Morelli was producing child pornography, much less in possession of it. In the case of Harrison, the Supreme Court of Canada addressed police misconduct, and in that case saw fit to exclude a sizable quantity of drugs where misleading in-court testimony was the police misconduct at issue. Granted, the police conduct, if it's intentionally misleading, is further down the spectrum of seriousness of police misconduct. However, in this case, the respondent submits that the misleading effect in this case, the errors in the preparation of the ITO are sufficiently serious to motivate this court to exclude the evidence and to distance itself accordingly from the police conduct in this case, which is nothing short of grossly negligent. This primarily having regard to the two principal objects at Section 24.2 of truth-seeking and maintaining the repute of the administration of justice. If there are no further questions at the first grant factor, I'll proceed to the second factor, arguing that the impact on the charter-protected interests of the accused in this case was severe. Returning to Justice Dixon and Hunter and Southam, Justice Dixon as he then was, pardon me, Section 8 guarantees the right of all Canadian citizens to be left alone. On the plain reading of the text of Section 8, it guarantees the right to be secure against unreasonable search and seizure. The legitimate interest of Mr. Morelli in this case was to have a search of his home and personal computer properly justified in advance by a proper showing of cause. These rights were not accorded to him. He was denied the full protection of Section 8 of the Charter, and as a result, police conducted a wide search of his home, his personal computer, seized his personal computer, removed it from his possession, and the personal computer, in broad and neutral terms, is the location where most Canadian citizens nowadays will keep their very most private information, their banking information, their medical records.
Sorry. On that point, in this case, the facts were that the computer technician was invited into the home and was able to view the home page that was open there. Your client didn't rush in and turn off his computer. He allowed the gentleman to come in and see everything. So doesn't that negate your submission, or at least dampen your submission with respect to his expectation of privacy?
It may be said, Justice, that in some minimal sense, the objective reasonableness of the accused's expectation of privacy may be diminished by the situation you describe. However, Mr. Morelli invited Mr. Hunjet into his home for a very limited purpose. And he did not, in doing so, waive the full protection of Section 8 of the Charter with respect to state action. And the state action is what is at issue here. It's the failure of police to properly justify their search of Mr. Morelli's home, the result of which was to expose his very most private pieces of information and the location over which he enjoys the highest subjective expectation of privacy to their view, and results in them seizing the personal computer and removing it for analysis.
I just don't totally understand the answer. I mean, if you let someone look at your computer, then doesn't that speak against you saying that you have this great expectation of privacy? Your particular client, others may, but your client apparently didn't.
With respect, Justice, there's no suggestion that this was not a search within the meaning of that term at Section 8. And having established the breach of Section 8, at 24.2, we consider the charter-protected interests of the accused, which were impacted by the failure to properly justify a search of his home. And the mere fact that a technician was invited into the home does not diminish the expectation of privacy to such an extent that we ought to consider this factor as pointing towards inclusion of the evidence as opposed to exclusion, which in the respondent's submission, this factor points strongly towards. At the third stage, the interests of society in an adjudication of the case on its merits weighed against factors 1 and 2, require the exclusion of the evidence. There's no doubt that this is reliable evidence that was obtained in breach of the Charter, and there's no doubt that this is crucial to the Crown's case. However, if I can draw the Court's attention to two cases cited in the Respondent's factum, the case of Regina against Dillon at the Ontario Court of Appeal and Regina against Nguyen at the Ontario Superior Court. These are cases where police carelessness led to a breach of the Charter, led to a warrant being improperly issued, and as a result, there's no finding of bad faith in these cases. Furthermore, these are cases that led to highly reliable evidence, which is also very important to the Crown's case. However, both in Dillon and Nguyen, the Court saw fit to exclude the evidence at Section 24.2. And that was because, despite the reliability of the evidence, the long-term harm to the repute of the administration of justice outweighed the interests of society in securing a conviction in those cases. And I draw the Court's attention to the charges in those cases. The charge in Dillon was related to this possession of stolen paint, leading to the police gaining access to the accused's home. And in Nguyen, the charge was cultivation of marijuana. And so in both these cases, arguably of a less serious nature, of a less inflammatory nature than possession of child pornography, we see the very same legal issues, no finding of bad faith, reliable evidence, but at the same time, the repute of the administration of justice demanded in those cases that the evidence be excluded. And that's because the integrity of the prior authorization process is really what's at issue.
But don't you think that when a child's safety is at stake, or children's in general, that's a much more important social objective than, stolen paint or even possibly the cultivation of marijuana, which mostly will be smoked by people in a situation of consent?
Your question, Justice, raises the issue of the seriousness of the offense at the third stage of the grant analysis. And the majority for the Supreme Court of Canada was quite clear on this point, that the seriousness of the offense cuts both ways. And that's because just as society's interest in securing a conviction increases with the seriousness of the offense, so does the accused's interest in receiving the full benefit of the substantive and procedural protections guaranteed to them under the Charter.
So you're saying it's a two-way sword. It slices both ways.
It would be inappropriate for the court to hold that the seriousness of the offense was a factor pointing towards inclusion of the evidence. At best, it's a neutral factor.
But doesn't my colleague's point cut against the importance of the two cases you've cited to us as precedents for this particular case?
The legal issue, the harm to the repute of the administration of justice is the very same in all these cases. And that's because we're policed to be allowed to be as careless as they were in this case, to be as negligent in the discharge of their duty of full and frank disclosure as they were in this case. Over a long-term prospective basis, the administration of justice would be brought into serious disrepute.
What's at issue here is the police trying to deal with an offense that's extremely difficult to discover and prosecute because it is committed privately. When we're talking about the administration of justice and the repute of the administration of justice, don't you think Canadians would say, when you're looking at child pornography, the potential harm to children, the justice system ought to cut the police a little bit of slack and let this evidence in, even if they haven't complied technically with every aspect of the ITO jurisprudence.
Chief Justice, the difficulty of prosecuting crimes is not a factor identified in the Supreme Court's decision in Grant as a factor which would militate in favor of inclusion of the evidence.
But we could always modify the law if we chose.
Certainly, Chief Justice, but
I believe you were to argue on existing authorities, so please continue.
And this relates back to my colleague's submission about blurring legal requirements. At this stage in the appellate process, it's incumbent upon this court to ensure that its ruling will be applied on a long-term prospective basis in a manner which will enhance rather than detract from the repute of the administration of justice. And I believe you have my reasons for why the repute would be harmed by inclusion in this case. And if there are no further questions, those are my submissions.
Thank you. Reply? Ms. McKinnon?
I would like to make 2 points in reply. First, my friends have argued that it was equally plausible that the respondent erased his computer and then seized his activities with child pornography. However, this is not the standard that we are to apply. The question of reasonableness is not whether there is another inference that could be made, but at this stage of the analysis, whether or not there was any basis on which the inference made by the authorizing justice of the peace was reasonable. And secondly, my friends have raised the case from the Ontario Court of Appeal, the Queen and Dillon, in which the evidence was excluded under Section 24(2) of the Charter because the police conduct in that case was characterized as negligent. However, that case is distinguishable from the one before us on its facts. In Dillon, the affiant misstated in the ITO that he saw actual paint cans in the respondent's, in the accused's possession in that case. There was a factual misstatement in the ITO, which is not present before us. Furthermore, there was a finding at trial in that case that the ITO was misleading, and there is no finding to that nature in this case. Thank you.
Thank you very much. The court will take its decision on reserve, and the court will adjourn. I understand there's another case about to proceed. At 4 o'clock, could we begin with that, or is that too soon? Okay, we'll see if we can be back for 4. Thank you.